So, the two accused here, former President Jacob Zuma alongside Thales, they've now put forward an application for a permanent stay of prosecution. Reasonable prospects of success on both sides?
Well, that depends on what the judge makes of this application. Just to give a background as well, remember that when a person is accused of a crime, it's the NPA, the National Prosecuting Authority, who institutes that prosecution. They can only do so if there is a reasonable foreseeability of a successful prosecution. The NPA have now indicated that they are proceeding against both Jacob Zuma and Thales. But Jacob Zuma has now approached the court, in other words the judge, to say the NPA is making a mistake. There's been numerous delays in this matter.
But who's to blame for that delay? Because he himself has been accused of adopting this Stalingrad approach to this particular criminal case.
No, exactly, and that's what the NPA will say as well. Remember, Advocate Billy Downer is representing the NPA in this matter.
And he's on all the hand.
No, he is. He's a very experienced prosecutor. He's dealt with many high-profile cases.
And much familiar with this case.
Yes, exactly. He's been with this case from the outset. I mean, this case, as you heard, it's come from 2002, even earlier than that. So there's a long history associated with this case. I see that Jacob Zuma is also saying that he's suffering anxiety and there's personal prejudice that he's suffering. He's obviously emphasizing the fact that he should be entitled to a fair and a speedy trial. But I do think that that argument is not going to carry a lot of weight. As you said, you know, this approach of Jacob Zuma has been to kick the can down the road for as long as possible, to delay matters as long as possible. He's taken every single decision on appeal that he's been able to, and I would be surprised if the permanent stay of prosecution is granted.
All right, let's now, Ulrich, speak about some of what he outlined. This is now his defense attorney. The legal strategy. They said at the time when he appeared, that was in July of this year, at that same court, they said that their strategy is going to center around 4 pillars. And we've already spoken about the one, which is the delays in the trial itself. But he then speaks about pre-trial irregularities. What are we talking about there?
Well, remember the whole spy tape saga, all of that, and the admissibility of those recorded conversations, how they were deemed to be inadmissible initially, and now they have been deemed to be admissible. He's emphasized that a lot, saying that the NPA hasn't been playing, open cards with everyone. They've been hiding certain information. They've been hiding evidence that they are now intending on using, and those can be deemed to be pre-trial irregularities. At the end of the day, you know, if the state says to the court, here's our case, this is what it is centered upon, we have sufficient evidence to do that, this matter must proceed. And that is what the judge is going to have to consider, because remember that if a person is prosecuted and that person is acquitted, so he's found not guilty at the end of the trial, he is entitled to institute a claim for malicious prosecution against the state. And that could be his relief at the end of the day. So if the state proceeds and says, we definitely have a good chance of success here and a reasonable foreseeability, then the judge will side with them and say, Mr. Zuma, if you say that you're being prejudiced so much and that the NPA is so wrong, then come prove it in an open court. And if we find that that is the case, then you will have an opportunity to sue the state after this matter has been finalized in order to try and recover your funds, the losses that you incurred as a result of this trial.
Well, isn't that the opportunity then for him to argue political interference, for example, because that's one of the pillars out of these 4 that he puts forward? Remember the issue of the spy tapes, which have already spoken about them. In fact, when this case was dropped, as a result of that, it was on the basis of political interference, but it was then later reversed at the Supreme Court of Appeal. So is this still very much a point of contention, political interference?
It will definitely be for the judge to consider. Remember that this is an ex-president. I mean, when Sean Abrams was head of the NPA, they initially decided not to prosecute. Then it was taken on appeal. Then the court said, no, well, there is sufficient grounds, you must prosecute. So there's definitely been political interference. There's absolutely no doubt about it. There will always be when it is an ex-president of the country that's being accused of a crime. But that's not the test. At the end of the day, the test is whether there is sufficient evidence in possession of the state which could lead to a successful prosecution. And that is the test, and that is what the judge will have to consider most importantly.
Because what's always been awkward about this case, or what's always been strange about this case, Ulrich Roux, which is what the former president is now saying, that the time or what he expected should have been done, instead of prejudicing him now, would have been to try him alongside Shabbir Sheikh, who was convicted back then. Wasn't that strange?
It is.
At the very beginning, because Bulelani Ngcuka said, yes, there was this prima facie case against the former president, but prospects of success were a bit wishy-washy. Yet you have Shabbir Sheikh convicted on the one side.
No, definitely, definitely. And that is a point of contention that the state will have to deal with. But remember, in their favor, Shabbir Sheikh has already been convicted on mostly the same evidence that they're going to adduce against Jacob Zuma. So that does play in their favor. There's no time limit pertaining to when a person can be prosecuted or not. So there's nothing that prohibits them from instituting the prosecution now. Their strongest argument on that will be that, remember, when Shabbir Sheikh was tried and was convicted, the spy tapes, so-called spy tapes, were not available. It was not available to the state to use. And this has made a big difference in their case against Jacob Zuma in trying to prove these charges against him. So they will have to address it, but I don't think it's the begin and end all of this matter. The fact that he wasn't tried with Shabbir Sheikh doesn't prejudice the state so much, or him.
Let's talk about the last element then of these four pillars, Ulrich, the forensic prejudice. What is that? What are they talking about there?
Well, there again, he's saying that there's so much information that hasn't been brought to light by the state that prejudices him, that they're hiding certain information. Again, I'm referring to the spy tapes, etc., etc. And he's saying that, how can he prepare for his trial if he's not being furnished with all of the information and all of the details that the state is intending on using during this trial. I mean, the case docket in this matter is massive. As you know, 783 charges. All of those charges must be, or counts, excuse me, all those counts must be proven. It's a vast amount of information that's going to have to be presented to the court.
And let's just remind the viewers about where those 783 counts come from. It's as a result of the alleged 500,000 rand bribery that would have been given to the former president, deputy president then, by, of course, arranged by his former financial advisor, Shabbir Sheikh. So that would have been over the period of what? 10 years.
10 years, huh? That was
and
it,
that added up to 4 million rand.
Exactly, yeah. So how the counts work, you remember, he's charged with fraud, corruption, racketeering, and money laundering. Those are the 4 charges, but there are 783 counts of those charges. So 783 incidents where those crimes were allegedly committed. And all of those incidents will have to be proven.
All right, Ulrich Roux.